Oyez, oyez, oyez. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Busk. Good morning.
Good morning.
I know that wherever you are in your various places, I hope it's raining in Midland at least, Mr. Guerrero. It's raining in Eastland right now. Houston maybe is raining. I believe that's where you are, Mr. Stone. So we're all quite moist and damp, but we're ready to proceed with our next case today. At this time, the court would call cause number 11-19-341, CV Texas Petroleum Land Management versus McMillan. Mr. Stone, are you ready to proceed?
Yes, Your Honor.
You may.
May it please the court. My name is Jeremy Stone, and I'm pleased to represent the plaintiffs and appellants in this case, Texas Property Land Management, LLC, Robert Ralph Riggs, Elizabeth Ann Riggs Lawrence, and Jean Hancock Riggs Weller. This case is a dispute over mineral interests in Howard County. The dispute really is pretty specific. I know there's a lot of paper in the record, but I think that the issues really can be narrowed down. The common source, I don't think so far there hasn't been any dispute really over the chain of title so much. It's just whether there is one deed that the appellee's claim is not valid. So the common source is from A.M. McMillan, who was conveyed in an undivided 50-acre tract or undivided 50-acre interest in the minerals in a 200-acre tract in Howard County. Mr. McMillan was married. His wife's name was Minnie. Mr. McMillan died August 6, 1932.
Have you ever seen a mineral interest conveyed in this way? I did a lot of oil and gas law before I came on the bench, but I've never seen someone say you get a 50-acre undivided mineral interest in 200 acres. Have you ever seen that before?
To be honest, I was unfamiliar with it. I had to read it a few times because I was getting confused over whether they had, how could he, convey.
Yeah, I assume that's a 1/4 mineral interest. Is that right?
I think that our pleadings have the interest that we are claiming that we own, but since I don't think that was a point of dispute that we've had so far, then I don't have that information in front of me, Your Honor.
So you all know the answer, but I don't know the answer. That the hen deed conveys 16 2/3 acres of a 200-acre interest. I assume that's a 1/12 interest.
You're I'm kind of on the spot here with the math, Your Honor.
That's right. Go ahead.
I'm sorry.
Well, that's right. We understand the basic facts. You had Mr. McMillan who died, who then has a will. He has this Republic as the executor, but he's also the trustee. The executor can convey without the consent of many. The trustee cannot.
I think that states it pretty well, Your Honor. If you want me to, I can just get right into the meat of the dispute, and we can go that way.
Yeah, okay. You don't have much time, so.
Okay. First of all, can I share my screen and show some of the appendix, or do you want me to just refer to the appendix?
That's certainly fine if you'd like to share your screen.
Okay, I think it might be helpful. Let me try to do it. Oh, yeah, the host has disabled it. So
okay,
we can't do that.
At some level, you're over our head. So just make reference to it.
That's fine. I know your honors have the documents and have read them. So I'll just refer to the documents by their appendix. So appellee's appendix. And that's not my appendix, that's the defendant's appellee's appendix C has the will. And as Your Honor said, the RNB is the trustee, was appointed the trustee as well as the executor of the estate. Now, I think it's important to note here that as executor, the first part of the will states that the executor shall pay all of the expenses, including my funeral expenses and expenses incident to my last illness, and also all estate and inheritance taxes assessed my estate, and the expenses incident to the probating of this will shall be paid out of the principal of the general asset of my estate.
Okay, is that language important? Out of principal and general assets, does that include real property? And isn't there plenty of assets to cover any debts without taking them from the trust?
I think that there may have been, Your Honor. I think that the only evidence in the case regarding the assets were what appellees pointed out, but those assets were not pointed out at the summary judgment hearing. But I think it may be a distinction without a difference in this case, because R&B was appointed the executor, but also given broad powers as a trustee. And I understand that the trustee language in the will always says with the consent of many.
Yeah, like 4 or 5 times.
It does. But there was a, I think this also falls under the Broadmoor case, though, which we cited. It's 635 Southwest 2nd, 572. And that case holds that an executor who's also given the powers of a trustee can transfer property without having for it to be for the payment of debts. This will gave R&B pretty broad powers to transfer property. Now, as far as the actual conveyance document, Your Honors, if you look at the Hen deed, for example, which is our Appendix 5, and it's also Appellee's Appendix D. It states that it's in consideration for $10, right? So, if you're looking at the paper, you're not thinking
that's common. That's
right.
In any oil and gas conveyance. Right?
We don't know if there was more money paid or not, but what it does say is that this conveyance is for the purpose of partitioning certain oil and mineral properties owned jointly by said A.M. McMillan and Albert G. Hen, legal title to which was vested in said A.M. McMillan.
How do you have legal title? I mean, how do you have title in real property unless you've had a conveyance into you that complies with the statute of frauds?
We don't know what the underlying documents were between Mr. Hen and Mr. McMillan. There could have been written contracts between the two. Some of the case law that we've cited.
But if there's written contracts between the two, that might be a contract between them, but that's not a conveyance, right? You have to meet the statute of frauds for a conveyance. You may say, gee, I made you a loan in order for you to buy that property, and I'm entitled to my money back, but that doesn't mean that you have a right to the property. And so, but what you're telling me is we don't have any documents that show what the conveyance is into Mr. Hen in the first place.
That's correct.
Okay.
I mean, it could have been, I think that the statute of frauds argument, first of all, was not raised, by the defendants, in the original summary judgment briefing, but I don't think it's an issue in this.
Was it raised in argument?
I wasn't at the hearing.
Okay.
I don't recall if it was raised at the argument or not.
Record, yeah.
And I'm not sure when it came up, but I don't think that the statute of frauds is an issue in this case, because I don't think there's a dispute that McMillan owned the property, and there's no dispute that R&B had the authority to convey the property, which it did. I mean, there's an issue of I mean,
Yeah, they convey it as the executor, right?
that's what it says.
Right, and all of that property as defined in the will is, all of that property is in the trust. So how does the executor convey trust property? And do we have some document that conveys from the trust to the estate so that the estate executor can convey that property? Do we have that document that shows the trust conveyed to the estate so that the executor could convey it to Mr. Henn?
We don't have that document. We have the same entity, the RNB, who acts jointly as an administrator and trustee, taking the action in the case.
Yes.
And so we also don't I do understand that a testamentary trust is created here. We also don't have a document, filed in the real estate records from the, estates to the trust. But I think, like I said, I think those may be distinctions without a difference, because I think it comes down to what was required to transfer or to convey the property. And if you look at the example that appellees gave, I think, they say that that's evidence that the conveyance was made without the consent of many. First of all, there is nothing in the will that says that the consent needs to be in writing. And that Miss McMillan was not an owner of the property that was required by the statute of frauds to sign anything. I think that when you look at the Henn deed and the Henn.
Okay, so let's assume that argument is correct. Let's assume for a minute that many could have consented orally. How do you prove your chain of title if you can't prove consent?
Well, I don't think it's up to us to prove. Well, I think we can prove consent by the circumstantial evidence, first of all. And I think that because the will and the case law provides that the broad powers given to the trustee, the purchaser doesn't have to look outside for authority to do it. So I think that given that the conveyance was made with no objection at the time, I think that evidence would have to be shown that would say that there wasn't consent. But okay. I think that there's
the deed into Mr. Henn is done by the executor. The executor doesn't have to get Minnie's consent. Why would if the bank becomes confused as to which hat they have on, why would they even seek Minnie's consent if they think that they're both executor and trustee and they can do what they want? Why would they even seek Minnie's consent? I mean, there's nothing in the document that says, having obtained Minnie's consent, we convey, right?
Right.
Okay.
Well, I think,
and they're saying we're the executor and we are conveying. Why would the executor have gotten Minnie's consent if they're conveying as the executor?
I think the way that I read the will and the way that that the purpose of it is that as executor, pay all the debts, right? And then everything else, you have broad authority, RNB, to dispose of the property with the consent of Minnie. We don't want you to do anything. It's for the purpose of supporting Minnie and his child. But we're going to give you broad authority to do what's in the best interest of everything with the consent of Minnie. So I think that the way it could be read is that as executor, who also has the powers of a trustee, any kind of disposition of property would be done with the consent of Minnie. I think it can be assumed that Minnie has consented to these actions, especially when you're talking about transferring property of record. I mean, both the Henn and the Curry deed were conveyed within a year of or within a year of Mr. McMillan's death.
And they both have very similar language, don't they?
They're almost identical.
Right.
But
yet in 1955, the banks goes, let's file this other document so that we can ensure that the trust property that was conveyed is with the consent of many. But we don't have that document with regard to Mr. Henn, but we do have a 1963 document. Can you address that 1963 document for me?
I can, Your Honor. Can I say one thing about the Henn? The Curry deed. So the Curry ratification came about in 1955, and it says that someone raised a question, and so they filed this ratification. But one thing you can look at also is that a big difference, I think, between the Curry deed and the Henn deed is that the Henn deed was filed and recorded almost immediately within a couple of months in February of 1934. The Curry deed was not filed until 1940. So, that creates some question, when you have a piece of paper that's hanging around for 7 years and then you file it, that could be the question. And I think that it's evidence in our favor that because there's no question, that many consented. So I will address the 1963 ratification. That appeared in the probate records of Mr. McMillan. Unfortunately, we did not have that as lawyers at the time of the summary judgment briefing and hearing. The client did have it. It was in a different folder because of different counties or whatever. We don't have a declaration or anything on file as to why there would be good cause to allow it. But I think objectively, I say we don't have a declaration because the client did have it. We admit the client had it. We didn't have it in time. But if you look at the record objectively, good cause, I think, is there. And to not allow the ratification, if this case turns on that ratification, which I don't think it should have to, but if it does turn on it, then I think good cause is there and it should be allowed because there is no, it wasn't like this was a final summary judgment and the case went away and we're sitting on it, waiting until the last moment to spring it on everybody. This was an interlocutory.
Let's assume that it should have been allowed and that we've got it before us to argue about. What's your argument on it?
I'm sorry, I didn't catch the first part. I'm sorry.
Yeah, let's assume that the ratification should have been admitted. It wasn't admitted. We're considering it now. What is your argument as to the 1963 ratification?
It ratifies everything that that RMB did. Minnie says in there, there's some question. I approve of everything that the RMB did as executor and trustee. And so if they're saying there's no ratification there's no written ratification signed by Minnie, there's a written ratification signed by Minnie that she approves of everything. Okay. One last thing, I shouldn't say last thing, but one thing I would like to address a little bit more with the 1963 ratification is that when the summary judgment motions were set, and this is briefed, so you can stop me if I'm being repetitive, but when the motions were set for hearing, defendant's appellee's motion was set first, and the court would not set ours at the same time, it set it later. When we filed and sought leave to supplement the record with that 1963 ratification, the court specifically held that it was timely. It was timely as a matter of law, and the court held that it was timely for our counter motion for summary judgment. But then when the court granted defendant summary judgment, didn't let us have our hearing on and said that it was moot. So I think that if this case turns on that written ratification, again, like I said, I don't think it should. If it turns on it, then the court erred in holding that our counter motion was moot because it had extra evidence in it. And that extra evidence was also, I'm sorry.
Hear the motion of the McMillan folks because they got it set? Was it set first, and did you make a motion to continue so that they could be heard together in advance of that summary judgment hearing?
I don't recall a motion to continue it, Your Honor.
Okay, or a motion that they be set together, they be heard together?
I don't think there was a motion to do that.
Okay, all right. So you were, at the time, you were okay with going ahead with their motion because you thought your motion would be heard within a week or so?
At that time of the hearing, I cannot recall if we as lawyers had that ratification or not. I'd have to go back and look. I know that it was after the hearing that we supplemented it. I don't think that we got it as lawyers from the client until after that hearing. But we supplemented it right away. Our hearing was still set. The court hadn't ruled and had requested additional briefing. We were continuing to brief the issues, Your Honor.
Okay.
The information that you say was included in your supplemental motion for summary judgment, or at least that you supplemented your summary judgment with, did you submit that evidence as well in your response to the defendant's motion for summary judgment, which was to be heard first?
We didn't have it in time, Your Honor. It wasn't with that one. It was in our motion for leave. It was in the motion related to Nancy Higgs, a pro se defendant party. And it was in our motion to reconsider based on all these issues.
Okay, but you're not saying, since you did not submit it and it was not admitted, you're not saying that the appellee doesn't have the right to attack that document in every way, including statute of frauds. You're not saying, you're not making that argument, right?
That for the ratification.
Is, how can I make a statute of frauds argument against a document that's not admitted and I wasn't provided in advance of the hearing? Now that you inserted into the appeal, can't I make every argument as to that document?
Yes, Your Honor. I wasn't aware that they were doing that as to that document, but I mean,
All right. Thank you very much, Mr. Stone. Your argument time is up. When the clock resets, Mr. Guerrero, it is now reset. Are you ready to proceed?
Yes, Your Honor.
Thank you.
Your Honor, I represent the appellees in this case, the McMillan appellees, Dorothy Comback McMillan, Catherine McMillan, and the Austin Trust Company. May it please the court and counsel, I think that Justice Williams has very aptly pinpointed the issues here. At the heart of this question is whether the executor of the A.M. McMillan estate had the power and authority to convey real property to George Henn from the estate. The answer is no, for a variety of reasons.
Mr. Guerrero?
Yes, Your Honor.
Is that so? Your argument is there's a defect in the Henn deed. Is that a void or a voidable defect?
It is void. It is void under case law, under Texas case law, Your Honor. It is undoubtedly, and I don't think it's in dispute, that this was a deed from the executor. And there's some confusion in this case and red herrings, really. The trustees' actions have almost nothing to do with the central issue here, because the trustee and the executor, while the same bank was fulfilling both obligations, in my mind, they have to be looked at as two separate people doing two separate work functions. As the executor, the bank had no authority under the will to assign out real property. The will gave the executor three separate authorities or abilities to do things and nothing more. The first was to pay estate debts. The second was to distribute the estate property that belonged to Minnie McMillan. The third was to distribute the residue to the family trust. And the executor did not need any consent from Minnie McMillan, Mr. McMillan's wife, in order to carry out any duties as the executor. The will of A.M. McMillan does not provide for any such requirement, any approval on her part. So the question really is, under either the will or Texas case law, did the executor have the authority to do it? We say no. He had no authority under the will because the will does not allow for anything outside of those three categories to be accomplished in order to execute a real property deed. The Texas case law is pretty clear on real property. In an estate, the executor must pay debts from first funds coming into land, according to Freeman versus Tinsley. The first funds here are $89,000 worth of assets in the estate, according to the inventory filed by the executor. That equates.
That was some equivalent to like $1 million now or something like that.
It's adjusted for inflation as of 2020 when we had the briefing in this case. That was $1.8 million. Yes, you're correct. So there were ample funds here to pay off debts. The second thing that I think is very important to note is that before in Texas case law under the Terrell versus McMillan case that we've cited to, the executor must pay debt from cash, assets, personal belongings, that sort of thing, prior to being allowed to sell real property in order to pay debts. There's virtually no chance that this debt was so large that mineral interest had to be transferred to him. So under the Texas case law, I don't think that the action was appropriate on the part of the executor. The third is that an executor under the Terrell versus Terrell case that we cited to cannot partition undivided interest in an estate property. You can't do it under the law. So even the act of this deed, which explicitly says that it was a partition deed, even that act runs afoul of the law. The Freeman case holds that if there is any absence of proof of estate debt, the sale of estate assets is void. That particular sale, and the burden of proof is on the appellants. That is under the Smith versus Hobbs case that we cited to. The appellants have the burden of proof to present evidence of debt that necessitated this sale, and they haven't done it. There is absolutely no evidence in the record, no evidence in the county record of Howard County that would indicate anything different. They just don't have it.
Let me ask another question. We get to the Hen and the Curry conveyances by the executor. Let's assume for a minute that the Hen conveyance is valid. That would give a mineral estate, and I didn't see anything in the record that indicated the executive rights had been split off.
Your Honor, I don't have any information as to whether that occurred or not. I assume not, because I didn't see it either.
Right. And so if they have executive rights, that means they have the right to come on the property, to drill, and to make leases. Is there anything in the chain of title that shows that Hen ever drilled or made leases for this property to be drilled?
No, Your Honor, to answer your question, that's it shows exactly the opposite from 1934 when all of this happened until 2017 when the appellants purchased the minerals from the Hen heirs.
Purchase
I'm sorry.
Purchase minerals from devisees of Hen, but they have never exercised their mineral rights as far as what the record shows.
That's correct, Your Honor. There is nothing in the Howard County records that would indicate any leasing, any sales, any transfers, anything from 1934 to 2017. There is nothing in the record. There's nothing that we found in the Howard County records either. So it begs the question: what was this all about? It baffles me, frankly. But the fact is that in Hen's own estate records that were provided by the Hen heirs, there's no mention of this mineral ownership, even though there's a delineation of a slew of other mineral ownerships that don't have anything to do with this particular property listed there. So, from the record, it doesn't even appear that Hen was aware or understood that he owned it or hadn't done anything with it. So, from that standpoint, I think that's exactly correct. The absence of evidence in this appeal is glaring. I'm sorry.
Address the comparison of the Curry conveyance to the Hen conveyance, the Curry consent with the Hen ratification.
They're very similar. The deeds and the ratifications are other than the parties involved, almost identical. But what we would argue to the court is the ratifications are irrelevant because the executor needed no consent from Minnie McMillan whatsoever.
Yet she comes in and she consents in 1955.
Correct. And were the
in 1963 we have a ratification in 1963. Can you compare those to the 55 consent to the 63 ratification?
My best guess, and there's not a lot of evidence as to the mechanics of it, Your Honor, but what I would speculate, and it's mere speculation on my part, but what I suspect happened is that somebody started doing due diligence on some of this property for one reason or another at different periods of time, be it a bank or a, what have you. And the question came up because from the chain of title, it doesn't make a lot of sense that Hen is even in it. We would argue that the executor became a stranger to title, and the deed into Hen is a stray, misnomer as far as the chain of title is concerned, because the executor had no authority to do it. That deed is void, and that's central to our argument. Had the bank acted as trustee, that's a different story, because the trustee, by consent of many, of course, that was 30 years later that it was filed, but conceivably, it's possible that would be a valid valid transfer. But that's not what happened here.
Do you have any case law that says that a consent of conveyance of real property has to comply with the statute of frauds?
Well, Your Honor, we have advanced the statute of frauds theory, and the court is dead on here. We believe for the duration of the trial setting and through the summary judgment hearing that we were dealing with written instruments. So the idea that statute of frauds would even come up doesn't make any sense in that context. Once this ratification came in, basically within the confines of this appeal, the the question was, well, okay, where is the writing? Any document, any sale of property has to be documented in Texas because of the statute of frauds. I mean, it's got to be put in writing. It's got to be signed by the grantor, and otherwise it doesn't comply.
Is the consent of many to the Curry conveyance, is that effective? Do you agree that that's effective?
I don't believe so, Your Honor. I'd have to look back at the Curry deed, but I believe that the verbiage is pretty identical. I think in that case, yeah, I think that in the case of both of those deeds, because the executor is the one that did it, they're void. But that's not a fight that we're.
Assume for a minute that it's voidable, not void.
Okay. All right.
Would the consent of many ratify the conveyance to Mr. Curry?
I would still say no, Your Honor. Based on the research that we've done, if it's not in the will and under the law, the executor, the bank as executor, had no authority to sell real property without exhausting the estate assets or the personal property, the cash, what have you. They had the executor had no authority to sell off real property or convey real property to satisfy a debt. So no, I would say that the ratification is a red herring.
Your position is that at the time that either the Curry or the Hen conveyance was made, it's void, and whether she later consented or ratified is not important.
Correct. Because that really just speaks to whether or not the trustee, the bank as trustee, a completely different hat, a completely different person, whether she consented to them is the only spot in that will where the need for consent is there. It has nothing to do with the role of the executor. So it's no different than if somebody came into my chain of title for the house that I owned, sold it to a third party, and then McMillan ratified that sale. It's not of any consequence to whether or not I still own the house. These folks are all just strangers to title at that point. And any title lawyer worth his salt is going to object to that, that stray line of chain of title.
Who has the duty then to prove that the executor did not convey the properties to satisfy debt or taxes?
That is on the appellants, Your Honor. The onus is on the party that purchased the property, and that's in the cases that we've cited to. Let me look. That is going to be the Smith versus Hobbs case. I believe the Freeman case also addresses that. The burden, if there is a challenge to a sale out of an estate, the burden is on the appellants to show that the debt existed. So they're the purchasers of the property, and the appellants here are the successors in interest. So,
but the documents themselves don't say they're being sold for debt. They say that they are conveying property that is somehow jointly owned but not titled.
Right.
And they themselves belie the issue of debt.
I'm sorry?
The documents themselves denied the issue of debt.
Yeah, it doesn't make a lot of sense. And I will say that there is absolutely no evidence within the record anywhere prior to the deed to Hen that Hen owned any part of that mineral interest. The fact is that the appellants had the onus to bring that to the court's attention. It is not in the record, and my humble opinion is that's because there isn't one. I don't know what happened here, but it's just as likely that Hen owned a portion of these minerals as it is that the executor and Hen conspired to commit a fraud on the estate. Both theories are completely unsupported by evidence. They're just pure conjecture. So I don't think that there's any good instruction.
Documents themselves, the conveyances to Curry and to Hen, and then the consent from many and the ratification from many, do they at least create a fact question? And if not, why not?
Your Honor, I would say no, because under the state of the law in Texas and the case law that we've cited to, it does not matter. Many's consent is completely and entirely irrelevant as to the issue of whether she thought that the sale was good. Doesn't have any bearing on what the executor could and could not do. The fact is that, and it's a hard line, but the fact is that the only conceivable way that property could have been transferred out of the estate would have been if it was transferred by the trustee out of the subsequent trust that was created. Because under the probate code that we cited to 101.001, as soon as Mr. McMillan passed, that the property passes just instantly to the beneficiaries that it's supposed to go to. In this case, it didn't go to Minnie because she received the house and personal belongings and that sort of thing, and then had the benefit of the trust for the duration of her lifetime. But the trust is the entity or the individual that owned the real property here, the mineral interest, because the real property went directly into that trust. The executor did not have any right to sell off the real property because it wasn't even in the estate at that point, would be my argument. Your Honor, for those reasons, I see that my time is almost up. No, wait, it is. We pray for the reasons that we discussed that that the court affirms the trial court's judgment. And thank you.
Thank you very much. Mr. Stone, when the clock resets, and it has, you're permitted to give a 5-minute rebuttal. Mr. Stone, you're on mute.
Thank you, Your Honor. I believe this is the first time that I have heard opposing counsel state that the Curry conveyance was invalid. Up until now, it's been my understanding from the briefing that the Curry conveyance was the example of what should have been done. I think that, again, I believe that, these papers that are in front of the court do create, at very minimum, a genuine issue of material fact, because you've got a conveyance that is made by the same entity, that's the executor and the trustee. It does say executor on the conveyance. It's done in the same way that another conveyance was made to Curry. And it seems like a reasonable inference, or it is a reasonable inference to make, that if there's no question made as to the Hen conveyance, the Hen deed, that should be held to be any less valid than the Curry deed, which wasn't recorded for several years and needed a ratification because there was a question about its propriety. I also think that counsel has the burdens wrong. on who needs to show, debts, for example, and those kinds of things. The Freeman case that they rely on, there was no specific power to sell in Freeman like there is here. I think this case is similar to the case that we've cited, which is Terrell versus McCone, 43 Southwest 2, another very old case. We're citing cases from a long time ago. But that was a trespass to try title case where the will gave power to the executors to pay the debts. And the court held that, it's assumed that if the executor has this power, then there are debts to be paid. Again, the conveyance shows that as between RNB, who had the power to convey, and Hen, as well as Curry, that there was something owed to those men, and the conveyance was made. And to just briefly state, this wasn't a petition of, estate property like is usually objected to with, taking one piece of land and splitting it up amongst heirs. This is, again, conveying mineral interests that these gentlemen obviously had some kind of business relationship, and Mr. McMillan owned the legal title to, giving those other gentlemen their title after McMillan's death. For those reasons, Your Honor, and those in our briefing, we respectfully request that the court reverse the trial court, and for all their relief to which we may be granted, or that we may be entitled to. Thank you.
Thank you very much. Gentlemen, your case has now been submitted. The court will be in recess